Thank you very much. We are all very excited to be here for this panel of security claims, and we are also very excited that we are sitting in the right order according to the list here, so it's a good start. Yeah, let me present us before we start the discussion. My name is Asger Lunde, and I'm a partner at Copenhagen Economics, that is a European economic consultancy, and I head our dispute practice. I do expert work in competition, commercial, and security claims, and I also have an academic background as a professor in economics, currently adjoined at NUC in Chapel Hill. And on the panel with me, I have in the middle Roger A. Cooper, as a lawyer and partner at Cleary Gottlieb. Roger leads Cleary Gottlieb's security and M&A litigation practice. He has a particularly strong record in representing foreign issuers in U.S. courts and handling matters that cross borders and has international dimensions. And then we have Chris Feige, that is an economist and partner at an analysis group. Chris specializes in areas of finance, security, and financial markets. He has worked on a range of security and valuation projects in the UK and Europe. He has hands-on experience in evaluating shareholder reliance and the estimation of portfolio prices in the UK, Section 90A matters, and he also has recent experience on the Steinhoff matter across jurisdictions in front of Dutch and South African courts. And on the far left, we have Kate Ellis, that comes with a lawyer background and is vice president of the settlement administration at Verita. She leads a team of international security settlements and US government administrations, and her work involves coordinating with various stakeholders, ensuring compliance with legal requirements, and executing program strategies. So before we turn to the matter, I would just like to briefly introduce what we are talking about here. So we're talking about security claims, and security claims usually or always arise because of alleged violation of security laws. So that would result in harms to investors. And this can happen in the primary market, where there is a misrepresentation of financial statements in an IPO process, or it can be in the secondary market, where misrepresentations usually has to do with failure to disclose information or to misrepresent information related to the companies in matter. So in these circumstances, you would then see that the stock price would not react correctly until there is a so-called corrective disclosure in the market, and the harm that then occurs to the shareholders would be from transaction on inflated prices. And in this environment, the harm usually by economists are quantified in one of two ways, depending on jurisdiction mostly. And one approach is called the artificial inflation method, where you essentially conduct an event study and try to figure out when this corrective disclosure emerged, what was then the reaction of the stock prices. That can be a challenge for several reasons. For one thing, the circumstances may have changed quite significantly in the market from the time when the misrepresentation was made to the time when the disclosure was actually made in the market. So it may not be possible to completely go back to the circumstances that you had. Also, one thing that I find interesting from the more econometrician's point of view is that this is a theory that was developed like 40 years ago and has been used in more or less the same way, whereas the financial econometrics literature has evolved substantially with the advent of time-varying volatility model and high-frequency data econometrics, which is especially interesting when you are trying to identify the effect of a news on a stock price. Because if you take some of these features into account, you should be able to more precisely identify that, which should be interesting to especially the defendants, because it usually would lead to a lower abnormal return. Alternatively, you see damages being quantified using a so-called recessionary method, which essentially tries to unwind the trades that was done under false pretension. So you would resend the trade and go back to as nothing has happened. That requires some more legal work, because you have to prove materiality. So that you have to prove that the investor acted on material information. You have to prove that they had relied on that, and you have to be able to say something about loss causation. I think we would like to start by looking at what kind of security class actions are being brought to the market these days. And I think, Roger, you would take us off on that.
Thanks, Asger. So yeah, in the U.S., I think Jeremy Lieberman yesterday pointed out that in the U.S. we're kind of in the sort of modern era of securities class actions, let's say, began in 1995 when there was a change in the law in the U.S. And that was when Congress adopted the PSLRA that changed the requirements and made it harder for plaintiffs to bring claims, or made it sort of imposed on them more demanding requirements in light of what was perceived to be too much litigation that was baseless and that was imposing too many costs on public companies. If you look at the history of cases kind of that were filed after that change in the law, for the first 10 or 15 years, what we mostly saw were what I call quantitative statement cases. So financial statement type cases where the challenged information, the challenged disclosures were in financial statements. They were, the numbers were wrong, maybe the books were cooked, whatever it might be, and then there was clear correction of that information through a restatement or something else that happened later, and that was the kind of corrective disclosure that we were looking at. That wasn't every case, but that was what dominated the kinds of cases that were filed. But a change really happened somewhere maybe 10 or so years ago, where we see many, many more cases that are filed based upon qualitative information. So statements, disclosures that the company makes about its commitments to the environment, about its commitments to having an ethical culture, its commitments to complying with the law, to statements about its controls. And a lot of these statements that get challenged are fairly generic in kind, and the corrective disclosures that we see that bring on the case, right, that lead to the stock drop, are also different in kind. So it's not where the company comes out and actually makes a statement, necessarily where it comes out and makes a statement that we didn't comply in this way, but rather maybe there's an article in the Wall Street Journal that raises questions about how the company is operating its business and the stock drops. Or a short seller puts out a report that lays out a case for why the company isn't doing what it said. Or maybe there's just some other trauma that occurs that happens to the company, and the result of that is that plaintiffs are able to say, well, look, this would have never happened had you been operating in the way that you described in the general statement. So maybe the company didn't actually say something that was specific to the trauma or the event that occurred, but they're linked in a kind of general way. So those are really the cases that dominate now what we see in the U.S. We still have financial statement cases, obviously, but those are much fewer in kind. And I think as we see kind of these qualitative cases develop, I think they fit into the kind of ESG mold that we've been talking about, that we all talk about. We see some climate cases, obviously a lot on governance issues as well, cases that might involve corruption issues. Recently, we've gone from kind of greenwashing cases to AI washing, and the SEC has brought a couple cases against financial advisors related to AI washing, that is saying you're using AI tools or promoting your AI in a way that exaggerates what you're actually doing, or they're not actually, the tools aren't working the way that you describe them. So we're starting to see that in cases. I think those are going to be issues that are going to continue to dominate the cases we see. And I'll say lastly, this is a little bit different, but the other bucket that I think is out there, we have a lot of cases brought related to crypto tokens and whether the distribution of the tokens was a violation of the U.S. securities laws because it was the sale of unregistered securities. And so the question there is whether the tokens are actually securities. The SEC's brought some cases, but there's a lot of private cases that have been brought by investors in crypto, so we'll see how those play out.
Very interesting. So Chris, the UK-Europe market is probably more narrow. Well, what kind of developments are we seeing there?
Yeah, I mean, I think actually very consistent. Over the last 10 years, I'd say certainly the UK has grown massively in the Section 90, 90A cases, and I do a lot of work in Amsterdam, and that market seems to have grown a lot as well. Obviously, the US has more history of kind of 30, 40 years of this, but it's growing massively. And I think the types of cases and the event-driven types of cases are the kind of new thing that people are struggling with. It's simple when there's a disclosure of an EBITDA being wrong, and kind of everyone knows how to handle that, but courts now especially, and probably looking to the US a lot, particularly in Europe, not so much in the UK, but looking to the US to, okay, well, how are you handling this? Is this a real case? Should we be considering a relevant period that goes back to some vague disclosure 10 years ago that just didn't quite specify the potential risks? But broadly, I mean, similar stuff, really.
From the administrator's point of view, are you seeing anything that right now that you're finding particularly interesting?
With the types of cases, I think it is consistent with these event-driven cases that Roger suggested. The event-driven litigations really for claims administration have no impact to our process, so it's a stock drop at the end of the day. We have seen a lot of SPAC cases, special purpose acquisition companies. These do bring complexities to administration. It's an unusual, atypical security type. They're often exchanged for different types of security during the SPAC, after the SPAC. Some operate like reverse stock splits, mergers, or reverse mergers. So all of that brings a lot of complexity to our administrations.
Very good. If we think about the sort of the life cycle of a claim, it's natural to continue with the developments for early dismissal. I understand, Roger, that that's something that is quite interesting in the US.
Yeah, so is it okay now? No, let's hold on a minute. I think as most of you know, Jeremy mentioned this yesterday as well, right? So the first stage in a US case, a securities class action, but a lot of other class actions is before you even get to the certification stage, there's an opportunity for the defendants to make a motion to dismiss the case based upon the adequacy of the pleadings. And in the securities case during that time, there's an automatic stay of discovery, so the plaintiffs have to plead their facts without the benefit of getting any discovery from the defendants, so based on public information or the investigation that they've done, talking to witnesses and gathering what they can from other sources. Something like a short seller report or a Wall Street Journal article that really has dug in on issues can be quite helpful and beneficial to the pleadings. But there's a number of requirements for the case to go forward, for the court to rule that it's not dismissed. But what we've seen in some recent cases, in both last year and now this year, from the U.S. Supreme Court is both last year in a case and now with a couple of cases that are before the court, the possibility at least of the U.S. Supreme Court narrowing and making it tighter, making it harder for the plaintiffs to bring these claims successfully. And last year we had the Macquarie case, and the issue there was whether whether there's a pure omission claim. Okay, so if the defendant issuer fails to satisfy a duty under SEC rules to disclose certain information, so it doesn't disclose that, is that a basis for a securities fraud claim? And you mentioned actually, omission of information. The Supreme Court said no. It said because of the statute that we have, it limits at least 10b-5 claims, ordinary fraud claim, just to misleading statements. So it really is where you speak and that information is false or in some way misleading because just of the way you disclose it or because of what you leave out. And so omission really only becomes actionable where it's matched with some other statement that's not correct or is misleading because of what's omitted. That is I think a change of law. It's a change of law in the Second Circuit for sure, where the court really had for years focused on the possibility of pure omission claims where there's a duty to disclose information. There's two cases now before the Supreme Court. Actually, the NVIDIA case probably being argued right now before the U.S. Supreme Court. And in the NVIDIA case, there's actually two questions. One is whether the plaintiffs can rely on expert work to plead their claim, and it's where they need to provide. Plaintiff needs to provide enough facts to particularize facts to support the elements, but where they don't have those facts from information that's available from the company or about the company publicly, can they have an expert look at what is available and then give an opinion and use that expert work to plead? The Ninth Circuit said it was permissible, and the Supreme Court's now going to consider that and has taken the case up. So that'll be interesting to see what they do there. The other piece in that case is just whether on the scienter element, the knowledge element, what level of detail is required to be pleaded in a complaint about contrary information that was available that contradicts what the individuals or the company stated publicly. And then the last case is the Meta case that was argued last week. It's a little bit different. It goes to risk factors and whether a risk factor where the company says we may be subject to certain risks that may cause reputational harm to the company. Is that actionable? Is it misleading when that event, what's the risk identified has already occurred and it's not disclosed? And so instead of saying, this has happened, it's, here's the consequence, they simply say it may occur. Seems like a really technical issue, but it's actually fairly common in cases. So we'll see what the court says there. They seem to be leaning toward the defendants, at least in narrowing the ability for plaintiffs to challenge that kind of disclosure.
So that all things equal would make the system more defense-friendly?
Correct, that's right.
Yeah. Is there something similar happening in the UK?
Yeah, I mean, I'm not a lawyer, so lawyers will speak better to this than I will. But in terms of, the UK, I think, is relatively similar in a sense. You need to particularize the claim and go to the court, and it's a collective action rather than a class action. But for the group to be together, they need to have, good facts to support the claim, and then the judge can decide whether that's an acceptable collection of claimants. What's I think interesting in the Netherlands certainly is the first stage in these cases for lawyers and companies and for experts is not really a filing by anyone. It's often these sort of active claiming groups. I think there are people in this room that where the funders and the groups will get together and go find claimants who think we were harmed, we held shares. They're often the sort of big investment firms and those types of people who hold shares. They'll bring them together and they'll write a letter to the company and say, you did this thing wrong. You should have disclosed all these different things historically. And we were harmed. We hold 100 million shares, and we were harmed by this amount. And that's when then we get involved. There hasn't been anything filed in court yet. We often get involved, evaluate the evidence. I mean, sometimes they'll have a sort of claimant expert as well who will do some sort of event studies analysis and try and figure out what the claim should be. We'll look at it and sort of pressure test it, see if it makes sense. Some of these claims are going to hold, some of them won't. Try and figure out what a reasonable place to be, and then really work towards settlement a lot of the time. And that's often all before anything has even gone to court. Often it's a year, 2 years into the case as we see it before anything's filed in court. And that's almost a threat from the claimant side to say, we're going to file if you don't really come to the table here to try and settle. And even then, obviously, once the claim's filed, there's the kind of initial dismissal. The judge can say this doesn't work, and all the similar stuff, I think, to the UK or the US, but they're all called different things, the same idea. But there's this really long run-up beforehand that we get involved in that makes it kind of interesting and often leads to settlement before it ever gets to court.
And then the next stage is sort of the certification state. And Roger, maybe you can sort of where's the bar right now in the US?
Yeah, so it's worth noting that I think we have about 225 securities class actions filed in the US each year, and approximately more or less 50% of them, about half, are dismissed at the motion to dismiss stage. So it leaves about 100 of these cases that go forward to the class cert stage, more or less, right? And that's the next stage then if the complaint survives a motion. And there's no real set time under the rules when this is going to happen. It's sort of as soon as practicable. Usually it's a few months into the discovery. The plaintiffs do get the benefit of some of the discovery. It doesn't wait until the end of discovery, but to make their motion. And let me just kind of set the stage, I think, and then to explain where we are with class certification in securities cases. If you go back, I think we heard earlier today or yesterday that our rule 23, which governs class actions, was amended in 1966, and that provided for B3 classes for damages, and then one of the requirements there is that there's predominance, right? So that common issues predominate over individualized issues, and for securities fraud cases, that created a problem because one of the elements of fraud is reliance. And kind of in the early years of these securities cases after Rule 23 changed, the law was all over. Like, how can these cases go forward? You have to look at what each investor did, what each investor relied on, and how is that not a classic individual issue that would defeat any kind of certification. So in the late 80s, there's a case called Basic v. Levinson. The Supreme Court said, okay, we're going to solve this. We're going to agree that it's a problem, but they followed some economists who said, yeah, but look, in a market that's efficient, right, all material information is incorporated into the price, and so investors who purchase, kind of based on or relying on the price are effectively relying on the challenged information, the false or misleading information, and so you get around the individualized issue of reliance, and the court said, in that case, when the market's efficient, there's a presumption of reliance. And sorry, I feel like I'm a historian here, but like the first kind of stage then of challenging class cert was for securities defendants, right, was to say, well, okay, is the market efficient, all right? And we didn't have a lot else to deal with. And that's a pretty hard argument to, you economists know, right, to make, right, to try to show that the market, for whatever reason, wasn't efficient. There were lots of efforts, but not much success. And we kind of were to the place in these cases where frankly, we weren't even challenging certification, right? There really wasn't an argument to make, and we were just agreeing to certification and really focusing on merit, summary judgment, or maybe settling the case. But there were continued efforts. There was a series of cases, Halliburton cases and Amgen case, and there, what really came out of those cases was, yeah, it's a presumption of reliance, but it's rebuttable, right? The defendants can rebut that. And then the question was, well, how do you do that? What kind of evidence? And so we now have the decision from the Supreme Court from 2021 in the Goldman Sachs case, and it still remains to be seen how powerful this is. But that case said, well, look, in an event-driven litigation, like a lot of the ones we have now, where the statements that are challenged are generic, and in the case of the Goldman matter, the statements were, the Goldman Sachs complies with law, that it manages its conflicts, that it doesn't do transactions that are conflicted, and then you had the SEC bring an action alleging that they had conflicts in connection with some collateralized debt instruments, and the stock dropped very dramatically. And so the court said, look, in cases where you have this kind of generic statements, and especially where the plaintiff, no one's arguing that when those statements were made, they had any price impact, right? So no front-end impact, right? It was just this kind of maintenance of the price because it just was consistent with the expectation that everyone had for the company, right? So I guess the idea is the inflation is already in the price. You look to the back end, you look to the drop to see what the price impact was. That's what the plaintiff said. And the Supreme Court said, well, look, where there's a mismatch, right, where you don't have a good match between the challenge statements and the corrective statements or what happens when the drop happens, then the link is severed and no certification should happen, right? Because now you've demonstrated actually that the presumption shouldn't apply because there really isn't, you can't really show a price impact. The Goldman case itself was dismissed ultimately on that grounds. So that theory, like after it went up to the Supreme Court and the Second Circuit a bunch of times, that was dismissed. And we've now had 3 cases this year dismissed, or they were dismissed because the court said no class certification. Actually, there may be some appeals, so there might not be fully dismissed, but no certification on the grounds that there was a mismatch between the front-end statements that are challenged and the alleged corrective disclosures or corrective statements at the end, and not enough to show that really there's any price impact. So I think it's promising. It's given defendants a new set of arguments to try to make in the right case where we really didn't have those. And it's probably the case, probably the situation that it's being kind of overplayed, like almost in every case. So we'll see really how things shake out. But that we've had 3 cases where no certification has occurred is, means it's a real development.
I can tell you too, we're already probably overplaying it in Europe. Just citing to the Goldman, and making the same case. It's not in a class certification phase. It's in a different phase, just sort of a judgment by an argument that this is just not a reasonable, certainly the relevant period. Often there's these sort of maintenance statements really early on in the relevant period, and saying like this is just not connected to the corrective disclosure, and those 2 things need to be connected really closely, and citing to the U.S. precedent. So I will see how. We'll try and use it in every single case, but we'll see what happens. But
it's super interesting that you're using it in the UK already.
Yeah, already citing to that same. The lawyers are. I'm not, but we're talking about it and explaining it and using the theory to try and sort of push back on some of these longer and vaguer claims.
How much economics do we need to bring forward at the certification stage in Europe?
Well, in the UK, there's no class certification because it's collective.
Yeah.
I can't speak as an expert in Amsterdam. Yesterday, you're probably hearing more good information. Prior to 2020, there wasn't class in securities, and I think it's just being tested now. So a lot of these same arguments, a lot of these same issues come up, in sort of either certifying a group or really the judge saying, you have a claim. This group has a reasonable claim. We're going to include these disclosures. We're going to calculate inflation based on these dates and these omissions or misstatements. So it's later, it's not the class certification phase, but it's the same arguments and the same issues that we then look at event studies for. I think one of the, what's interesting is the distinction between, in all cases there needs to be a misstatement, but how that's sort of decided is really different. In the UK, we worked on these Section 90 cases, and the first step is, was there something that should have been disclosed? And the questions that the courts are asking and the experts that we're working with and what we're testifying about are really about the kind of reasonable investor test and a much more holistic question of, would investors care about this information? I think in the US and in Amsterdam, people will look directly to an event study and say, when that information went into the market, did it drop by a material amount? Did the share price decline? In the UK, it's much more focused on, what we've had corporate brokers, sort of equity analysts that advise companies on disclosure who say, well, no, I know a lot about this industry. I know what investors care about. I know what drives the value of this share in the market. And so I can tell you effectively whether this is something that was a reasonable investor would have cared about. And it's a much more sort of qualitative question to answer the same exact question, a qualitative way to answer the same question, which is, did this need to be disclosed? Where the US and in Europe, I think it's a lot more just look at a stock drop. Did it drop? Was it material? And that's the answer.
But in the class cert context, in the Goldman analysis, we very much rely on expert work because you really need to look, especially have experts analyze kind of what was the stock price drop responding to, and you want to look at analyst reports and do a event study if you need to or whatever. But you need to like really do some hard quantitative work to put that together. Yeah. And because one argument is like there's a mismatch, but also it's good to be able to say and what the drop was responding to, the stock was responding to something else also entirely, and then you can and not anything linked to the original challenge statements.
Not to minimize. That's true. There's a lot of work to be done. We've done a lot. And actually, one of the things we've done in the U.S. as well, which I'd be interested in your thought, but on that kind of those vague disclosures, is had an expert, an equity analyst, or somebody who's an investor look at these earlier disclosures and note, like, look, analysts never paid any attention to these. If someone says we have world-class controls, and maybe the but-for disclosure would have been, we have really good controls, but things can go wrong. But no analyst, nobody in the market ever looked at those disclosures. Nobody cared, and so running the argument that effectively a different disclosure that was slightly, more specific but still pretty vague wasn't going to change anything. The share price wouldn't have changed, and so there's no price impact from any misstatement.
definitely make those arguments, but I think you'd have to also try to show that when the stock did react, it was reacting to something else, at least at the class cert stage, to convince a court to not certify on that basis. I mean, otherwise, I think you go to trial on that basis. Only very few cases go to trial, but to say, look, jury, seriously, these are the statements that misled the public. Look at, like what would been the but for world? What would they have said instead? How would that have affected the price? And I think you could have experts testify about that.
So how does that then come into the quantification when the economic experts are quantifying damage?
Yeah, I mean, I think, like as Roger was alluding to, it sounds like I was probably overstating it. Like a kind of event study sounds simple, but there's a lot that goes into that. Looking at an event study, understanding all the information that was disclosed on that day, maybe the day before, maybe the day after, understanding kind of the information environment of what people were looking at, what the market was looking at, and then what exactly was disclosed. Because tying the disclosure, you're saying there's this corrective disclosure that is correcting the misstatement. Well, often there's a disclosure that says a lot of things. Part of that is correcting the misstatement. Part of it is other information. Part of it is maybe tangentially related to the misstatement, but it's not specifically correcting the misstatement. And so the share price is going to react in a certain way. But there's a lot of work to be done, both looking at sort of intraday prices, understanding the entire information set in the market, and then just really digging into like the value of the information that's disclosed, potentially teasing that apart to understand, was there actual misstatement itself would it have caused, or did the correction cause a material change in the share price, or did the share price change materially that day, but for lots of other reasons that shouldn't be tied? So that's a lot of the work in the kind of event study in the US and in Europe, and not in the UK.
Not in the UK, but what happens then?
Unfortunate for defendants, although again, a lot of this doesn't get ultimately tested because so few cases go to trial. So it's really about the strength of your hand in a mediation or in a settlement posture, candidly. But the plaintiff does have the burden to prove damage, right? And so the defendants have a slightly easier time because you just have to raise problems, right? So somehow the plaintiffs have to figure out a way to disaggregate, right? What, like the drop in the stock that was actually caused by the alleged misstatement, and disaggregate that from any other exogenous, any other like fraud related information, whether it's market wide or company specific non-fraud information. And the experts, a lot of also what you do is to try to like point out all of the other factors here and how they're not untangling those things.
We have seen, particularly in some competition cases, that some of the courts has turned to demanding a theory of no harm. So, like when you, as you say, you cannot just refuse everything. You need to have a theory of no harm. Is that something that you're seeing in the UK?
In the UK, because we have the kind of rescission framework, right? Ultimately, if there is a material misstatement, then I haven't mentioned, but there's a huge amount of expert work and legal work, which is reliance. You mentioned it, but to prove reliance, that means that every single shareholder has to bring their investment documents, find them from 10 years ago a lot of the time, their models, their investment memoranda, like their notes from meetings, how they made the decision to invest in the share. And they have to provide those, and I worked on the Tesco, for example, that was an EBITDA misstatement. They had to show in their models that they were looking at EBITDA, that the EBITDA that would be different by the amount that Tesco was alleged to have misstated it by would have caused them to make a different decision. And you can imagine there's a lot of investors that aren't that focused on EBITDA. They're looking at multiples, but it's just one of many, or they're not looking at all. There's momentum investors, there's like quantitative investors, there's tracker funds. There's all sorts of investors that don't care about a company's EBITDA in one quarter. And so really pushing back and arguing that none of this is, these people don't have a reliance claim. Sure, there was a misstatement, sure, maybe it was material, but they don't have any claim. And so they would effectively fall to no claim, no harm. But there isn't then, well, it's still to be debated because none of them have ever gotten to the damages phase in the UK, but whether that would then mean you use sort of an inflation framework or a rescissionary framework. But you would use a rescissionary, I think a rescissionary framework would be the argument that a lot of people would make, in which case you kind of just unwind the transaction. Right. And so if they proved that there was a misstatement and they relied on it, then they kind of just unwind the transaction. Or
This is how it functions. Yes. Yes. So, Kate, the claims administration comes in after the case is settled and move to the notice phase. And I guess you can say that this is when the total pie has been agreed upon, and you come in and help to make sure that the pie is cut up in the right places in an orderly manner, so everybody get a fair share of the pie. But maybe you could tell us a bit about how this actually functions.
Sure. So, like you said, claims administration comes in after the cases have settled. And it may seem quite simple. I mean, we perform an administrative function. But claims administration can actually be quite nuanced. There are a lot of considerations, cross-jurisdictional and otherwise, that impact the process. In a nutshell, though, simply put, we handle the notice phase, we handle claims processing, we calculate the security claims based on the plan of allocation that is created by the economists, and then we ultimately pay the claimants a pro rata percentage of that calculated loss. I'll just talk briefly about the notice process first in security class actions. Yesterday, the panelists brought up that there's 2 ways to notify claimants. So it's typically a direct notice and then a publication notice. So for security class actions, we do both. We'll directly notice a claimant. We typically get transfer agent data of the record holders of the securities from the defendants, but this is usually a smaller population. What we rely heavily on in security class actions in the US is our broker outreach notification. So here we have a long list of brokers, financial institutions, intermediaries, known filers, and we will send them the notice and ask that they, research their databases and search for their underlying claimants who have purchased the security in the relevant period. And then we ask them to notice those constituents either for us or send us their contact information of those constituents, and we will then send the notice directly. The brokers are really an intricate part of the process. They're paid, they're compensated for this, and that compensation is usually limited by court orders. So maybe the court will say, okay, you can have 3 cents per notice you send out, or a nickel for every name and address you provide, things like that. We also do publication notices. Traditionally, it would be a news source like the Wall Street Journal. They talked a little bit about more modern publications. So for the past decade, we've offered publications on Facebook. Recently, it's more contemporary platforms. So TikTok, YouTube, even Reddit. Those type of publication notices really don't have the reach as, say, the Wall Street Journal, but they are good for more targeted, specific groups of investors you're looking for. So like Roger mentioned, the SEC is doing more crypto cases, and a lot of these are really lesser known. So with a social media publication, we can do targeted searches for, say, males ages 18 through 40 who search for certain crypto terms, who are in these, certain subreddits, things like that. So it's good for kind of a targeted search.
Yeah, maybe there's a follow-up questions on that, because we also talked a bit about that. We wanted to talk about cross-border and multi-jurisdictional cases, and I know you have worked on the Steinhoff case where that was filed in the Netherlands, in South Africa. What was the challenges around that?
Sure. So there's a lot of differences between a U.S. security class action administration and a European. We handled 2 of the largest European security class action settlements. One of the largest differences, I think, is the level of verification required for the claim. So like I mentioned, we handle the claims process. And as part of that, certain evidence is required by the claimants to validate their claim. In Europe, what we found is they required a KYC document for every claim that came in, so either a copy of the claimant's passport or identification. And they also required full documentation for every transaction that came in. A lot of our claims in security class actions, some of these claims have thousands, tens of thousands of transactions, and we're asking for all purchase and sale holding information. So, a full documentation to require evidence for all of the transactions, it's a lot. It's a lot of paperwork. It's a longer administration. It's more costly. The US tends to require less evidence, so we don't require KYC documentation. We also tend to require evidence to validate your claim on a threshold base. So typically we'll require documentation for all unknown filers. So if it's an individual filer or an unknown bulk filer. But then we will ask for documentation to substantiate a certain percentage of the losses. So we might decide that we want to have 85% of the entire recognized loss of the database. That needs to be documented. But oftentimes we have a few very large claims. So it might only be your top 200, 300 claims that we need full documentation on. And we might have kind of, several thousand in that lower 15% of the losses. So we really try to focus on kind of the high dollar claims. Or if it's an unknown bulk filer that we're not familiar with, we might request documentation there. We also supplement the verification with additional audits. So a price per share audit. We'll upload all the price history for the security and do a programmatic search just to make sure, does every trade in our system, was it purchased at a price trading during the correct range? And if it wasn't, those transactions are flagged and we'll follow up for documentation on those. Or we ensure claims are balanced, which is another audit. All of the purchase side, so if I have 100 shares on the purchase side, that has to equal 100 shares on the sale side. So that kind of protects the integrity of those claims filed for those that we don't require full documentation on.
Thank you very much. Chris, I'm curious about the Steinhoff case where you worked on in two jurisdictions as an economist. Were there any difference on what you should and could bring forward as the expert?
So it was in South Africa and the Netherlands. I think it made the settlement and very complicated because there were different pots of money from different entities to fund the settlement. Ultimately, the settlement, actually the calculation, the math itself was the same, and we used sort of an inflation approach. I don't know South African securities law as well as I should, but I'm sure I'm sure it has its nuances. We just kind of applied one approach, and the court accepted it, I think, given sort of the international experience and that it was what we're using in the Netherlands. But I imagine there were differences. But it just made the whole thing very complicated because you're dividing up claims between different places and then trying to calculate them separately.
And maybe as a final comment on the multi-jurisdictional, we see that more and more cases are being filed outside the US. What has caused this development, and where do you see it going? Roger.
Yeah, sure. I think one of the developments we've already talked about yesterday, but it's was the change in the law in the U.S. with the Morrison decision from the Supreme Court, U.S. Supreme Court in 2010, that meant that the cases that for purchase of securities that are not listed on a U.S. exchange or that aren't purchased in a domestic transaction, that those claims can no longer be, or there's a defense right against those claims being brought in the U.S. It's important to remember it's not jurisdictional. The court wasn't saying that there's not jurisdiction. It was saying that it's actually a merits issue. So I think where there is a place to bring those claims in another country, then we're seeing those being brought. There are instances still where there's an effort to kind of still bring them in the U.S. So if you can bring a U.S.-based claim because there's securities listed in the U.S., we do see complaints still filed also for securities listed on another exchange to try to bring them in. The court can exercise supplemental jurisdiction over those claims. And there's a good defense, right, for dismissing them, at least like a form non-convenience, right? They should be brought in the country where they're listed, and where the investors are. But there is sometimes an opportunity to try to settle all those claims together if you want to, and that's where you could actually effectively waive the defense on Morrison or waive a form non-argument, and you can, and it's happened. There's a Teva case that settled both U.S. law claims and Israeli law claims in the U.S. But I think we definitely see the proliferation of claims outside the U.S. And sometimes we have a U.S. claim and then a claim somewhere else, and their coordination becomes really important, and working together to figure out how to and strategizing which claims should go forward first, how to take positions in one jurisdiction that is not going to harm you in the other, and so on. It all becomes very important.
I think we have inflated our time, so thank you very much for your attention, and we are happy to continue the discussion in the break.